Welcome everybody to the weekly Probate Mastery Group coaching call. Anybody's getting stuck or anything new you figured out that you'd like to share?
Hey, Chad, I'll share a little bit. This is
Yeah.
perfect down in Miami. I have a VA that I got off of Upwork. She's been making calls for me between 9 and 11 in the morning. And I had to get on a call with her today because I checked on Mojo and I was comparing what I'm being charged on Upwork to her dialing time. So I had to comment on that. Hopefully she adjusts what she's been doing. But she's been getting me leads. I got 14 leads since we started in December. Some are people that's making a decision in the next couple of months coming up. Some have said that they have to wait for the probate they want to sell the property, but it's in probate. So what is it? I can tell them, hey, because I know from what I remember, it depends on the state that you could sell the property before the probate is complete.
You need court confirmation, but that does not mean that you can't go ahead and put it on the market now or give them a purchase agreement. In the state of Florida, it's not as complicated. During the course, you heard me talk a lot about California because it has the most complex process. But in Florida, you don't have no referee. They don't order an appraisal or get a referee opinion of value or BPO or anything like that. What they mainly want to see is what are the liabilities? What are the assets? And are they dumping it at such a low price that the liabilities can't be settled? Beyond that, the Florida court system doesn't seem to mind. I've seen them bought at 20 cents on the dollar and the judge approves it. So you just focus on, as long as they have the letters testamentary, if they've been granted the authority as the representative, go to a purchase agreement or a listing agreement and just move through it with the attorney. Typically, you're going to have, in a pre-COVID environment in Florida, usually you would have about a 2-week waiting period at most to get the approval and move forward with the transaction.
I appreciate that. I am in Miami, Florida now, but my market since 2015, it has been Atlanta. So I'm actually marketing in Fulton County because I was doing real estate up there since 2015. Just at the last year, since the last year, I've been more in Florida than up there.
Yeah. Well, that's great. So tell us about your VA. I'm assuming it's offshore VA.
She's in Jamaica. She's probably the 5th VA that I've used. The other one's never really worked out. And she's been working with me since December. She's great because she's done this before. I was like, I started the conversation with, hey, Tiffany, you're great. I really like you. I want to keep you on the team. However, I'm observing these things from a business owner's perspective. I feel long story short, she's on the clock for 5 hours, but she's only giving me 2.5 hours dialing time. I'm like, you're taking a lot of breaks. I get it. You have to take a break here and there, but you're on for 20 minutes. You're off for 20 minutes. You're on for 20, and I'm being charged for all that. So can we, bring that up? But other than that, she's good. The English is good, and she's getting me leads. That's for sure. Every week, she's putting them into the lead folder.
And are you looking at scaling this into the Miami market?
Yes, all the leads gave me a list from July, Miami-Dade, and we've been making calls to that list. It's just that I have my whole team for the most part. I was fixing and flipping up in the Atlanta market, so my team is mostly there. But yeah, I do closings, get some money coming in, and I definitely want to open up the market down here in Miami.
You might consider a Spanish-speaking VA to add as your Miami person.
For sure.
Cool. Lots of hands up. Thanks for sharing that, Herbert. Bruce, you're up first. How can I help you?
Yeah, I just thought about this day or two ago, and I wanted to wait until we got on today. So I have some clients, and this is probably a legal question, but I'll just throw it out there anyway. I have some clients. They own 2 properties here in Washington, and they live overseas. One of the spouses is a U.S. citizen, but the other one has lost their green card because they've stayed out of the country for such a long time now. Let's just say that the U.S. citizen passed away, and then they had to probate the property, and they're subjected to that higher tax rate if you don't have legal status here in the U.S. So have you heard of anything that has taken place like that? And what do you think I might, but obviously I'm going to direct them to an attorney, but I was thinking maybe, if something ever happened to them, then they might be facing a financial payout a little more than they have to. So
are they married?
Yes.
So can the foreign national spouse, can they get in the country on a travel tourist visa?
Yes.
So tell them to come back in on a tourist visa and then file there's a change of status form. I'm trying to think of the number of it. If she can re-enter on a tourist visa and then go directly to immigration and file for change of status, then she can probably recover that green card.
Right. Yeah, they've lost it a couple of times, so they just said the last time.
They're sovereign citizens, right? Are they more affluent and have a higher net worth?
Yeah.
I would recommend setting up, potentially, depending on their level of wealth, even an international asset protection trust. So just move all of their assets into the Cook Islands or Nevis and just forget about it. If they're going to be, global citizens, pick the one most beneficial jurisdiction in the world. So if they're affluent and they have wealth to protect, for about $30,000, they can set up either a bridge trust or a full-blown international asset protection trust. There's benefits to either, but if they're living across borders like that, it's very cheap insurance. How many people pay $1,000 a year for auto insurance? Like I do across my vehicles. So if you look at that over a 30-year, if you look at it as an estate planning tool and spread it over 30 years, you're basically paying $1,000 a year to have full legal liability. And you're in a jurisdiction where one of the great benefits is it costs somebody $250,000 to even file a lawsuit against you, because they have to pay a retainer fee and a filing fee in the Cook Islands equal to about $250,000. You got a 6-month statute of limitations. So if your defense counsel can keep the case open longer than 6 months, then it's dismissed. So there's a lot of legal protection that comes along with it, but it might also be the best. I think it sounds to me like what limited details I have, it's probably the best type of estate plan for an individual or a couple like that. So then they're not subject to any of this. They have a trust agreement that says what happens when party A or party B passes away, and their money is in a global and the toughest jurisdiction for anyone to get at in the country or in the world.
What did you call that? An international what?
International Asset Protection Trust.
Okay.
The other is a bridge trust. The difference there is, so there's a structure that's, I think it's trademarked by the law firm, but in Arizona, there's a law firm that will actually set up a International Asset Protection Trust. So I believe it's a Belize trust with a Cook Islands trustee. But the trust is then, there's a bridge created to an Arizona limited partnership that holds all of your assets. The difference there is you just report one page to the IRS when you have a bridge trust. If you ever get into a lawsuit or a divorce or something happens, you already have directed the trustee, if these events happen, then cross the bridge. With the bridge trust, it will automatically move your assets into the International Asset Protection Trust with all those protections. Then and only then does your IRS filing requirement become that of the actual international trust. It's lower cost to maintain over time. And as long as it's properly structured where the bridge is created when the international trust is created and you have no liability, there shouldn't be any issues. That one's going to be, they're both roughly about $30,000 to establish. The bridge trust will be $2,000 to $3,000 a year to maintain. And International Asset Protection Trust will be somewhere between $6,000 and $8,000 a year to maintain, depending on how much your CPA charges. But for more affluent people, especially ones who are kind of sovereign citizens that are crossing borders and subject to this jurisdiction's law and this for 6 months and this jurisdiction's for that, it's probably time for them to do something like that.
Revert back to Bruce. I don't even know if he's still there, but I think that what he was asking, the question he was asking was the FIRPTA, which is the Foreign Investor, it is called the Foreign Investment in Real Estate in Real Property Transfer Act, which is required any buyer of a U.S. real estate interest to withhold, any foreign buyer, of U.S. real estate to withhold 10% of the amount realized by a foreign seller. So FIRPTA is actually a law that was enacted in 1980, the Foreign Investment in Real Property Tax Act, to where if you look at our contracts, our sales agreement and our purchase contracts and everything, there's a section for FIRPTA in the Florida contract on the bottom. So I think, Bruce, that's what he was mentioning, that the decedent was foreign and so was his wife. They lived out of the country. So I think that if that's the case and that's how it's registered as title, they would automatically have to withhold it, or they would have to speak to a CPA that specializes in FIRPTA.
If the asset was held in trust, a foreign individual doesn't own it. A trust does.
Yeah. Okay. This is the first I hear that International Asset Protection Trust. So I definitely want to look into it. Thanks so much.
Follow the billionaires and politicians.
Okay, great. Thanks.
Yeah. Bill Gross, I see your hand up. How are you, sir?
I'm great, man. How are you?
Where's your VA this week? I guess it wasn't a VA. It was your admin.
Oh, yeah. Not here now. It's here this morning. We get it about every day. It's part of he's working virtual this morning, I guess you would say. First off, he asked about plans, and I just wanted to say my plan is, again, to do over 30 transactions. Hopefully, my number is 35 for this current year while I'm doing other things to build my business. all my lead generations in this probate space. I really appreciate from where I started this with you 3 years ago. Yesterday, got my first escrow, went to court, and we overbid on a court confirmation sale on a nice commercial property. I'm excited about that. I'm excited to share, when I took your training class, I was almost disappointed that you had all these vendors and you talked about how you had all these different people you worked with. And I just never had that experience. Maybe I did a trash out on one deal, or I did one other insurance referral and another. But I have a listing right now, and we haven't taken it to market. And I've done trash out, locksmith, estate sale, insurance, and firearms dealer. And we're still going.
It's almost time to bring in the social worker.
Well, they live on the East Coast, so they're already covered in that department. So I thought about that. So I'm going down the list looking for others, trying to figure out what else I can do to bring value. But I just want to, for those who are listening, maybe for the first time or as a reminder, for the idea is to look for opportunities. And a lot of these along the way, I go, I have to deal with this. I have to deal with that. But there are also opportunities to reach out to these vendors as part of my marketing, part of my business. And so I'm focused on coming from being a service. And as a result of that, my business is flourishing. And yeah, it's a lot more work that I'd like to do. And I have a team member helping me to help recruit things to your system as well. But anyhow, I just like to share with you the thrill of having 5 vendors so far, 1 property.
Yeah, well, that's awesome. So I think a lot of people freak out when they first see that vendor list. It's, oh my God, I need these 36 people. And it's true. Sometimes you can go 3 years and not really have to lean on them at all. But I've had some where I'm like, my gosh, when am I bringing the firemen in on this deal?
Oh, I left out because the cats, I guess in that city, they don't take cats out. So we had to call the animals group, and but we had to get the cat into a carrier. So that's a whole nother thing we had to do. I left that off. So this is one of those deals where we're going to go through your Rolodex, your list pretty deep this time.
Yeah. Well, that's awesome. It's a shame they're out of market because they would refer you everyone they possibly knew after the service you provided.
Oh, yes. But thanks.
Yeah. Denise, I think you were up next.
Oh, hi. Okay. So I'm new. I just finished the probate mastery course and I signed up for all the leads. I am building my team right now. I want to know from you or anybody here is that when they build their team, like the contractors, the property management, the nursing homes and all that stuff, do they put the link on their website, or do they just have these people listed?
You can put the title of the team member. Don't put the contact information, because who do you most not want to have access to that list?
Okay,
But your competitor.
yeah,
I didn't even keep a written list, a publicly facing written list. If you want to know who my vendors are, you look me in the eye first. And then the justification for that is, well, I need to understand. Once I understand your situation, I'll understand who on my team is best suited to help you. So it starts with just a simple conversation. We could sit down tomorrow at 3 or 5:30. Which of those works best for you? A lot of people will say, well, send me an email. Isn't there something you can send me? And a lot of folks will be the golden retriever sales dog. Oh yeah, let me just send you my most valuable asset. I'll send you my vendor list. And that's weak when you can say, well, actually, we don't really do the email thing. We prefer to meet face to face. This is a people business and we're here to help people. So I can email you a funny joke that I saw yesterday, but if this is, about the estate, why don't we just go ahead and meet so you can trust me? And it works every time. If they give you the brush off and try to get you to email all the details, that just means they don't see value in what you're offering. So you might as well take another pass at them. So it won't be often that you'll actually need your vendor list. For us, we kept it in the database, but you can use titles like in your marketing. You can say we have contractors, clean out crews, social workers, SPCA reps.
I just want to make a point what Denise was talking about regarding not to just send out your lists. And it's so funny because my mentor for my YouTube channel, in her course, she actually teaches people to use lead magnets, to use things like my preferred vendor list. And I'm now switching that up because I talked to my marketing guy who designs websites and a bunch of other stuff. And just use your booking calendar for everything.
Yeah.
And so now I'm changing things up, and that's actually going to save me a lot of time because now I don't have to create landing pages for those lead magnets. So that was a huge save for me. Thank you for mentioning that.
Okay, one other question. I do have a new client. She inherited her grandmother's and her mother's property. They both died like probably a month from each other. So
Is she representing both estates?
Yes. And she was granted the PR for one, but when she went to court to get the other, he said that she needed to be bonded. And the court, I think she told me that they wanted an attorney she had to go through an attorney to get bonded. And I told her, I don't know if you have to do that. So I went online and looked at bonding companies, and none of them said that you had to have an attorney. From what I gather, you pull off this application and you fill it out and send it back to them. I don't know. So
Yep. So I'm guessing one of the estates did have a will, and that will waived the bond, and the other did not. So they're requiring a bond. Is that right?
yes.
9 times out of 10, the court will actually waive the bond, even on intestate succession, if you ask. Usually the attorney knows enough to ask. The typical place to purchase the bond would be through a probate attorney's firm. It's not required or necessary to do it that way. You can go third party if you do. They intend to use an attorney for the
Yes, she does. But she was under the impression that she had to use a separate attorney to get the bond.
no.
And so
Just whoever she chooses to help with the probate will be able to help her get the bond or get the bond waived, hopefully.
all right. Well, thank you.
How are you, sir?
Good, doing a little thinking, but what I'd like to do, if you don't mind, is pick Helmut's brain. I see that he's still on there. I'd love to hear more about the script that they're using and the time that they're calling. I need to get on the phones pretty quick, and I'd love to get whatever tips he can.
Yeah. Perfect. You're up, man.
Cool. Yeah, more than happy to. And shout out to Richard De La Cruz. Him and Stanley and I, we do some role play every Tuesday and Thursday morning. So shout out to them. But yeah, Winston, one of the parts of the conversation today was me telling my VA that I want to start recording the calls because on Mojo, there's that option, but we haven't used it. And I told her it's for positive criticism, for feedback. I assume that she's using the ISP that I created. And that's what I use when I'm making the phone calls. I created a little ISP. That's what it's called, right? The ISP or USP that I created. I'm always fine tuning it, especially because we do the role play, Richard, I, and Stanley. And so I fine tune it here and there, but that's it. I just use the USP, and I asked my VA to do so. Whether she's using it or not, I'm not 100% sure.
Harry, would you mind just running through your script, doing a live role play?
Yeah, here I could. Let me just pull it up really quick. And I'm going to stumble through it a little bit because I've been adjusting it. But yeah, you want to start from the top?
I'd love just to listen and take notes.
No. Nope.
Nope.
Okay, ring. Hey, Winston, this is Hervik. How are you doing today?
I'm doing well.
Awesome, Winston. Great. Well, I'm calling today to introduce myself and my probate resource team, built to aid probate representatives in charge of settling estates. The value my resource team provides helps families in making more informed decisions within the probate realm, and which in the end can save you a significant amount of time and money. Let me ask you, Winston, do you have a few minutes so I can tell you more about the resources we provide, or do you feel you got a good grip on things so far?
I think I've got a pretty good grip. I've got a pretty good attorney, but my curiosity wants to hear for a minute or two,
Okay. Yeah, I'd want to keep going, but I don't know, I'm maybe a little shy, but that's my USP. That's my USP.
Winston, they've got a group that they've been meeting and doing role plays. It sounds like maybe you want to try to get an invite to that group. Richard's up next. Richard, jump in here, man.
Hey, how's everybody doing? Hey, a couple of questions here. What are your thoughts on presenting yourself as a company name when it's an outbound call and you say, I'm over here with integrated probate? Instead of saying your name, you just kind of like a company name. How do you feel about that?
I still think you should use your name, like just using just the first name. So this is Chad from Integrated Probate Solutions. I was calling because we were actually meeting with the clerk yesterday, and she gave us the names of all the families that we think we can help. So today we're reaching out to each and every one of you. Have you got 5 minutes? And just be Richard. It's okay to use if it's Richard from, some people are like, We Buy Houses Cheap LLC, and don't use a company name like that. If you have a transition specific brand, that's a brand created with sensitivity in mind, so it's great because it differentiates you, because anyone else will be calling from ABC Realty Corp or We Buy Houses LLC or Prosperity Hope Home Buyers or some shit like that. So it sounds like you've got a good brand that wouldn't put them on guard. It would elicit curiosity. So I would use it.
Okay, what about incorporating it or making it like some sort of company? Because one guy was like, wait a minute, right now. Oh, I repeated it. So what would you maybe legitimize it? I don't know if I'm using the right word.
I don't know if it doesn't necessarily need to be its own entity. It can be a DBA or just a brand. It's good to give them something to be able to look you up. So have a Facebook page, have a Facebook group, have a website with those things on it, with an about page. And even if you had brand.com on your about page, you can say this web asset is owned by ABC Real Estate LLC. You can always put that in there for compliance, but give them something somewhere to go find out more about your service. So a Facebook page, a website, and make that, put that brand front and center on that.
Cool. In the Probate Master, you spoke about putting together a list pendant class or pre-foreclosure.
It just comes down to timing. There's not really a whole lot of pre-foreclosure in the marketplace right now. I would expect that the beginning of that will be in March. Jerome Powell is just rattling his saber right now. I think what you're going to see is, and here's me and my crystal ball, but you've got a country strapped in consumer debt, strapped in student loan debt, auto debt, government debt, corporate debt. The Federal Reserve's buying junk bonds as fast as they can right now. They're about to slow that or taper that, the asset purchasing, and they're going to raise rates 3 to 4 times is what they're saying in the saber rattling starting in March. So what you're likely to see is equity prices go to hell, probably a 30 to 60% correction in stocks. Whenever they try to taper, it's going to look a lot like mid to late 2018. And you'll have a taper tantrum in the markets. That's when companies, when they lose access to cheap debt and they quit being subsidized, then they're likely to start laying off mid-level management. And those will be the first, that's the meat of the housing market. And then once those layoffs happen, inventory should ramp up. The market should kick in the other direction. And probably by Q3, we might see those actually start to roll through where I think this is a setup for subject to investing, probably a once in a lifetime opportunity to pick up assets subject to, because people have been buying payment, not price. And when their life situation or employment situation changes and they have to move and they can no longer sell that house for the price they paid at the same payment because rates have risen, then they're going to be stuck with the choice of, do we sit and let it eat cash? Do we turn it into a long-term rental, a short-term rental, or do we try to dump? So you've got some time to prepare is my point. I think it's probably mid to late 22. That timeline has gotten pushed out since early 2020 when I made the call on that. It all depends on how much intervention we see from the Federal Reserve and how long they keep rates suppressed to the levels they are. I think they're in a conundrum, and I think they may have to move rates and then move them right back. But if they do move rates 20, 25 basis points as they're threatening to, some people are going to get pinched because it's going to collapse equities prices, which is going to ramp up unemployment and jobs that matter. And that's going to spill over into housing. I don't care what the supply and demand is. It's going to come through. The people who overpaid 20, 30, 50,000 bucks aren't going to be able to get that same price if they have to sell the asset. So there'll be opportunity there. I'm not sure how big. It's probably not going to be on the scale of 2008 just yet. But as this sets in over time, if inflation continues to run out of control, which it's likely to, considering the amount of currency expansion they put into the economy, it could run for 5-10 years where you'll have opportunity to pick those up. So it's the reason it hasn't been released is mainly just timing. Like I don't want you to spend money on a course right now that's not that relevant. And I don't want to design a course that is based on look at the past pre-foreclosure or foreclosure crisis. I'd like to better understand what forces are causing it, what I see coming, and be able to talk about that in the course. So when the time's right, it's all there. It's just a matter of when does it make sense.
Okay, thank you. One more question. How can we download this recording or?
Easiest way is just go to Apple Podcast, any podcast platform. It's on Stitcher, Spotify, Apple, Amazon, and just download the podcast version. Okay. You can also download the YouTube video if you'd rather have the video.
Okay, got it. Thank you.
Yeah. All right. Dan the man, how are you?
How's everybody doing?
Happy New Year.
It's been a little bit, and so I'm reverting back to homework you had given me about Florida lawyers encouraging people to not file for 2 years in order to avoid something. And just a little search that I actually looked into, it says Section 733, 710 Florida statute states that a creditor's claim is barred if the creditor does not file a statement of claim in a decedent's estate within 2 years after the death of the decedent, Therefore, after 2 years, all claims from creditors of the decedent are permanently barred. So as soon
They never publish notice.
I'm sorry.
So is your interpretation of that, if they purposefully never publish a public notice to creditors, it still discharges the liability?
That's how it appears to be based on their advice to several people. If you remember, we were discussing something with a gentleman that was running into it, and I had heard about it twice in about a month. And as I read a little bit more of the statute, I'm not gonna lie, I didn't really delve much into a whole lot of it, but the basic understanding was they did have some stipulations after that he came to debt for mortgages and lien holders as far as to the property itself, but he did exclude some creditors from that. So the only stipulation was debt, not time frame of file. That's how I understood it, and that's probably why they continue to encourage that to be a factor in some people's estate plans. Or whenever.
It's actually written that way. You read the specific language. It didn't say if there's a failure to notify creditors then.
And I couldn't find it in the official statute as well to where it specified notice.
Thing is coming off of the attorney's website.
Yes. Yeah, this one came from I'm sorry, hold on.
Ed, are you in California?
Florida.
Oh, Florida. I know in California we have that. I was looking at the code the other day, and I know like probate advances, anyone who has a claim, unless they file it against the probate case or even if it's just been petitioned before, as long as they could put a lien on a house, but unless they file it against the probate case, it can be thrown out if they don't do it within a certain period of time. And I think in California, it's within 1 year from the date.
Yeah, and John Fraker was mentioning something about it was pretty much counterintuitive, and they were actually filing the probate in order to stop certain things. In Florida, myself, I had heard about it, and then another gentleman that came on heard that a lawyer was encouraging the family to wait until the second year to start the process itself. And the way that this was read, and the way that when I did the research, the only qualifier here is the passing of the person. It didn't have anything to do with filing any paperwork to start the probate. So several lawyers locally have encouraged to wait until the second year in order for some aspects of debt to fall off of the estate to where they wouldn't be able to claim it. I like I said, I've read into the statute and I can't find anything. It just says that if they don't within 2 years of the debt, no other qualifications, that is barred. Mortgage doesn't apply, but other debt like credit card or whatever it may be, smaller debts, I guess it would be. There's certain qualifiers, but attorneys are encouraging people to wait a little bit, especially that have smaller estates.
I'd be a little apprehensive in that regard. And I probably talked to a couple of my attorneys about that instead of just hearing that what you're hearing that some people are being told this from attorneys. Just because from a standpoint of creditor, you don't make payments for so many days, you get all these lates on your credit report. Okay, fine. This person has passed away. So the credit report's not going to matter so much. But ultimately, they then sell it off to a credit, recovery agency, and they do deep dive research to find people and to figure out what assets they may have had. And so there could be some potential where they would find it. And within that 2 years, they could still file the claim. And I wouldn't be surprised if they're looking to see if they have a probate case.
Correct. And there could be a possibility to where the lawyers are speculating or guessing that even though somebody has gone into some kind of a default, by the time credit companies get to collection agencies, by the time this and that happens, because of whether they're busy or the amount of debt, I don't know what the qualifiers are. They might not catch up to that time. And then after that, it'll just dissipate since the person's already passed away. I don't know the exact later.
And another solution in my thinking is that if the estate is thinking they're not going to have enough with how much mortgage liens there are, the value of the property, they don't have a lot of cash assets, that might be an opportunity to be an investor on the deal and partner with them to flip it so they could make more money. Look at ways that they can capitalize on what they do have, particularly with flipping the property, or can they get equity out of the property to go and do a flip and partner with you on the flip? They could be your gap funder to bring them some more money so that they could offset those losses of those debts.
That's helpful, and I appreciate that. Chad had given me the homework to figure out where I heard that and to back it up a little bit. So I try to do a little bit of that. And it was just informational. I looking into whatever avenues that I can help families or partner or whatever it may be all the time. But this is something that keeps peeking its head here around, and families are getting this advice, and it's backed up by a statute. So it's hard to argue that statute. You can't, it's difficult to make a lawyer rush when he thinks it's best for his client that they wait for 2 years. So that's where I was.
Chad, this is Jay Hawk. Can you guys hear me? Hey, I want to thank you, Dan, for actually raising that question, because it made me really do just a small dive here in Texas. That unsecured creditors have only 4 months in Texas.
4 months if notice is published.
All right, if notice.
What he's saying is, what the attorney in Florida is saying, don't publish anything. We're not even going to file this probate. We're going to wait 2 years and cut the creditors out of what they're due. So
yeah,
he's seeing that as being a super fiduciary and protecting the family. The creditors are going to look at that differently. And what I would say is common, if I were a creditor in the state of Florida and I could validate that statute, I would be a subscriber to the Social Security death list, and I would be filing I would be filing probate for these families. I would be the petitioner. As a creditor, I would petition the court and open probate. They can designate whoever the hell they want as a personal rep, but I'm gonna get my money. If I'm the creditor, I would be the one that petitioned the court. And if that's becoming commonplace, get ready, because you're gonna see that. You'll see savvy creditors actually open probate.
Oh,
Crazy.
If someone owed you 25 grand, you would petition. But yeah, in most states are that 4-month window. So from the time you petition for probate, you have to publish notice in a local newspaper for at least 21 days, and that remains open for 4 months. Then the court will actually say, all right, this is the final list of liabilities, list of assets, let's proceed. In some states like California, that's a much bigger window. And that's why California tends to drag on longer, because most people do have some liabilities, and that 12-month window leaves it open longer.
So if we have 1 minute, I can read the entire statute. It's not a long statute. It's actually from Florida, from the Senate. So 733-710, limitations on claims against the state. Let me make it bigger because I'm getting older. Notwithstanding any other provisions of the code, 2 years after the death of a person, neither the decedent's estate, the personal representative, if any, nor the beneficiary shall be liable for any claim of cause of action against the decedent, whether or not letters of administration have been issued, except as provided in this section. This section shall not apply to a creditor who has filed a claim pursuant to 733-702, which would be another one, within 2 years after the person's death and whose claim has not been paid or otherwise disposed of pursuant to another statute. This section shall not affect the lien of any duly recorded mortgage or security interest, or the lien of any person in possession of personal property, or the right to foreclose and enforce the mortgage or lien. So again, it just seems like that there's a loophole.
Yeah, if the creditor is not aware that a death occurred and they don't file probate, there's no obligation. I don't hear an obligation to publish. So it's what the attorney's doing. Seems like it would work. But again, savvy creditors, for example, you guys, my father just passed away. Wells Fargo didn't even wait for my mother to make contact. They just went ahead and shut down all of his accounts that he had opened those accounts when he was away working, and it wasn't a joint account. So they are obviously subscribed to the Social Security death database. So they throw the red flags as early as possible and take action. What you'll probably find is that it's the smaller creditors that are getting screwed in that.
Right. I appreciate everybody's time.
Yeah, thanks for the update, Dan. Good job doing your homework.
That was good. I really enjoyed that. That was helpful. My question is, it's pretty general. I've been looking for, or just exploring, different coaches, specifically in the probate space. And I'm curious if you're still, I know you had mentioned that you take on private clients. You're selective. I know you mentioned that as well, but I wanted to know if that's something you're considering doing again this year or at any time in the
We have a huge demand for it, but for me personally, in West Virginia, my father passed, and trying to stay close to my mother as she settles into a new reality, right? So I grew up in the only radio quiet zone left in the world, near the world's largest fully steerable radio telescope. So we don't have internet, we don't have cell phones in most places. The reason I'm hesitant to coach is I'm back and forth between my business life and my farm life, back and forth. So I don't feel like it's fair to people who might need me to help put a deal together, someone that needs an hour of my time, and I'm on the farm for 2 days and don't come back into cell service. So I just don't feel like I can show up at the level I want to for $1,000. I have not been taking on new coaching students. However, some of the CPEs that are on these calls frequently that are doing 7, 8, 7 figures at least are excellent coaches. And I need to build a system because we have had a considerable amount of interest in both group coaching as well as one-on-one coaching. So I don't have anything built right now. But we may have in this year. It's becoming obvious that a lot of folks have a desire for coaching, and I just need to get out of my own way. Stan, what do you mean by us being clear on our USP? What's the most efficient way to build a team? Do you recommend tapping your network of attorneys? Yeah, so the getting clear on your probate USP, that was the beginning of session 3, where we talk about who you are, how you got their information, what you want, and what can you offer, right? Hey, this is Chad. I've got a team of people here locally that help families going through probate. And as part of that, we visit the county clerk once a month, and we actually got your information from her. So I had a few minutes today. I just wanted to reach out, let you know what it is we can do, and just understand your situation, see how we might be able to help. What's been if you could delegate one thing right now, what would that be? So I disclosed briefly. I didn't go into my whole corporate introduction and tell them exactly what my business entity was, because I don't know until I see what service I'm going to use. But they now know at least my name is Chad. They know I got their information from the county clerk. They know that they're in a probate situation. And I'm asking them open-ended emotional questions to end, because I don't want a closed-ended, I don't want to give them the opportunity to say, yes, no, I don't need help, blah, blah, blah. So, I want to say there are a lot of things we can do to help. It starts with us understanding your situation. What's one thing you would delegate if you could today? And they almost can't help but respond to that. So that's what I mean by being clear and thorough in your USP. Your second question, what's the most efficient way to build a team of vendors? One at a time. Like, it's not something that you can really do in bulk. I tell folks, like, pull up an empty spreadsheet. Column A is what problems could they have. Column B is what solutions could I have, and then go build your team. Go find a solution. Go find a who for every cell in column B. And it might take you 5 years to fully complete that. We're all still building. I'm betting Bill Gross didn't go out and put a California federal firearms license dealer on his list in the beginning. But when the need arose, he went and did that. And he just used them on this last deal, on his first deal of the year. So you'll never stop building your vendor list. Start with the more common ones you're going to use in a state sale company: a contractor, a locksmith, a clean out crew, housekeepers, social workers. Think about what situations. Most of these homes will have personal property. Some of them will have holdover tenants that have never had a job and never will. And they want to live there, but the rest of the family wants to sell it. That's where a social worker comes in. So just think about, what are these scenarios that I'm likely to encounter, and what solutions do I have for each of those scenarios? Your last question was how to handle the question, how do you get paid? I'm currently wholesaling and won't be taking my pre-license. Well, good for you, getting your license in March. How do you get paid? The best response to that is, I'm not real sure until I really understand how we're going to help you. But one thing I can promise you is that we won't be paid a dime until we've delivered on everything we've promised. So you feel comfortable moving forward knowing that, and then just move on? Because until you actually know who you're bringing to the table, you don't know who's getting paid or what. Sometimes as an investor, you might realize you're not going to get that deal to fit the price, for a price that fits your strategy of fix and flip, but you have solid rapport. So you move them toward a brokerage conversation. And at that point that you say, well, listen, we take a 3%, our brokerage division takes 3% commission, and they offer a 3% cooperating broker. So it's 3%. That sound fair to you? Okay, great. And on the other example, it's you're not getting paid if you're the investor, if you're acquiring the asset. It's, you know what, listen, I'm actually going to pay your fees instead of you paying mine. Would that be okay with you guys? So I'll pick up the closing cost, I'll pay your side of the prorated taxes, everything else. So instead of me charging you a fee, I'll actually pay your fees. Does that sound good? Perfect. But try to defer it early in the conversation, because you really can't give them a valid answer until you know exactly what you're going to be doing for them.
Oh, that was really good. Thanks so much, Chad.
Yeah, thanks, Dan. Frank says, I don't have a mic. If I send a letter first, what would be the script to use when calling follow-up? If you go back to session 3, you'll see me jump on my soapbox and talk about why I hate scripts, because what is Zig Ziglar quote I think I have in there, timid salespeople have skinny kids. I don't think I'm doing you any service to give you a script, because I can get you off script in a matter of one obscure answer. There's just so many different possibilities with these estates there that it's impossible to script well. So that's why we teach the conversation framework of the probate USP, and then asking progressively more personal questions to gather information. As soon as you know there's real estate, you know that probate has been filed, and you know that there's an intention to sell the real estate or to do something with it, set the appointment, then start talking about the real estate. So I would just encourage you to go back through session 3. There is a script that I did upload into the course, because it's only good for a few seconds in a typical situation. It's so easy to get off script in these, and then you got marble mouth. You're like, so it's better to just really think through, you know, what could these people be going through, and what is my answer for that? You know, what's my solution for that? Marlene says, check out Starlink. So that was my whole plan in coming back here, Marlene, is I was on the very first beta list with Starlink, and they were supposed to have it to me in March, and then in August, and then in October. Now they kicked me to 2023. So I'm actually working on becoming a fiber optic ISP. We're going to raise capital and put in our own damn internet. So I don't know if I'm going to get it done before Elon gets it done.
Just try it out. I don't know how we pay them ahead of time. So they just responded to us after over a year, and finally got it. I was quite surprised that it's so amazingly great. Like I think
it's because I'm in such a rural area.
The only thing that we have here is AT&T, and the speed is 150. That's the fastest, and no other service provider. Because we're too far from the road, I'm literally in the middle of the woods. You can spend so much money for the fiber optic. It will cost so much because the original is analog, which is paid like 20 years ago. You know, so Starlink is now here. So we got it. I just got it July last year. I'm in Ohio.
Really? Yeah. They sent one dish here back in, I think it was June. One guy right on the county just north of me in Randolph County, literally 100 yards across the county line. They gave him his, it might've been in May or June, but for Pocahontas, the county I'm in, they actually kicked us to 23, and everybody I know got the same. So unfortunately, we're going to have to wait, but by that time, I will have raised some capital and put in fiber line and 500 meg fiber. So we just we're working through getting infrastructure grants and actually building it.
Good luck.
But I'm glad you got your Starlink. That's awesome. And I'm glad it's working out for you. I was pretty excited. Now I'm pretty jaded, but for now, I'm still in the camper running off the cell tower. All right, guys, I think we got a clear queue right at the top of the hour. I'm going to jump. Thank you guys always for being here. Great turnout this year. We've got some good momentum for the beginning of the year. So thanks for all the engagement, all the questions.
Thanks, Chad.
Thanks a lot, guys. Have a good day.